This is a video to be added to the Psychiatry section of the website. Legislation around consent and capacity. So, what do you already know? Question 1. In what year was the Mental Capacity Act created? 2005, 2004, 1998 or 2010? 2005 is the correct answer. Question 2. How many statutory principles are there in the Mental Capacity Act? Is there 10, 3, 5 or 8? The correct answer is 5. Question 3. What can people be detained for under the Mental Health Act? Is it new physical disorders, both mental and physical disorders, existing physical disorders, or mental disorders only? The correct answer is mental disorders only. So, let's move on to consent and capacity. In this video, we're going to talk about what is the Mental Capacity Act, what is the Equality Act, what is the Mental Health Act, and then go through a few situations where the Mental Health Act can be applied. And following this, there'll be a summary and some multiple choice questions at the end to test your knowledge. So, what is the Mental Capacity Act? This Act was created in 2005 with the purpose of providing a framework for acting on behalf of and making decisions of adults who lack capacity for any particular reason. Lacking capacity itself is when at any particular time a person cannot make a decision for themselves due to an impairment or disturbance in the function of their brain or mind. This type of impairment is both decision and time specific and cannot be applied all the time. Therefore, if a person cannot understand, retain, weigh the balance of information or communicate their decision, they lack capacity to make their own decisions. Within the Mental Capacity Act there are 5 statutory principles outlined, and these principles protect those who lack capacity and are fully in line with the Human Rights Act. These principles are: a person must be assumed to have capacity until it's established that they don't. Number 2, should not be treated as incapable until all steps to help them have been taken without success. Number 3, they shouldn't be treated as unable to make a decision just because that decision seems unwise. Just because we disagree with somebody's decision does not mean that they don't have capacity. 4, any decisions made under the Mental Capacity Act must be within the patient's best interests. So we cannot just make decisions for somebody because they're in our best interests. They must be in the best interest of the person involved. And number 5, before the act is done or the decision is made, it must be thought about how to do it in a way that is least restrictive to a person's rights and freedoms. So, if a decision has to be made for a patient, then it needs to be determined whether it is in their best interests. These are the things that need to be considered: equality, all relevant circumstances explored, is the patient likely to regain capacity? If this is likely, then certain decisions are unlikely to be made, as this will affect them for the rest of their lives. Can the patient take part in decision making? Some patients, although they lack capacity, can still help in making those decisions, so it's important to get them involved. The patient's wishes or past beliefs need to be considered also. There also needs to be the consideration of the views of the family or the lasting powers of attorney. Does the decision involve life-prolonging treatment? If so, then it really needs to be considered seriously. When the assessment has been completed, there will usually be a meeting, or, in serious cases where there's a lot at stake, there may have to be a best interest ruling. Patients who have nobody to represent them are allocated an independent mental capacity advocate. When a patient is detained under the Mental Health Act, the Mental Capacity Act cannot be used to authorise treatment of a mental disorder, as Part 4 of the Mental Health Act trumps the Mental Capacity Act, but the Mental Capacity Act can be used to treat physical disorders and people detained under the Mental Health Act. This is an important bit of legislation and an important bit of information to know, so I suggest going over this a little in detail and researching further into the matter. So, there are certain decisions that can never be made on behalf of a person lacking capacity. For example, Family matter under section 27. So this refers to marriage, sexual relationships, consent to divorce, consent to adoption, and discharging parental responsibilities. Voting rights. So a person who lacks capacity cannot be voted for. You cannot make a vote on behalf of them. Unlawful killing and assisted suicide under section 62 also falls under the decisions that can never be made on behalf of a person lacking capacity. Lasting power of attorney is something quite relevant to the Mental Capacity Act and is used when somebody gives another person the ability to act on their behalf, and this continues after a person no longer has capacity. These people can be asked to have control over finances and welfare, or both, and have to be registered with the Court of Protection before they can be used. Deprivation of liberty is when you are locked in a secure place and not free to leave, and can only be applied in circumstances where a person needs treatment but lacks the capacity to make decisions about themselves. Deprivation of liberty safeguards protects you from having your liberties taken away without good reason, and all patients not free to leave should be subject to this, according to the Supreme Court. Let's move on to the Equality Act. The Equality Act came into force in 2010 and provides a framework to protect everyone's rights to equal opportunity. So this merges previous legislation such as the Equal Pay Act, Sex Discrimination Act and Disability Discrimination Act into one place, so it's more comprehensive for us to look at. Under the Equality Act, you are classified as disabled if you have had a physical or mental impairment which prevents you from undergoing normal life in the long term. This Act provides people with disabilities from discrimination in regards to employment, education, and police. What is the Mental Health Act? In England and Wales, the Mental Health Act of 2007 provides a legal framework for the care and treatment of individuals with mental disorders. It's divided into several parts, with each part divided into a number of sections. Part 1 is the definitions. Part 2 is the civil sections, and the most important sections within this that we need to know are 2, 3, 4, 5, as well as sections 135, 136. This relates particularly to medical information that's relevant to us. Part 3 is the forensic section, involves sections 35 to 55 in relation to mentally ill people involved in crimes and prosecutions. Part 4 is related to consent for treatment, and this section clarifies the extent to which people under the Mental Health Act can have treatment without their consent. Sections in this only last a few months before further sections are required to continue this treatment. On this slide I've detailed the most important sections and a little information about them. Further information can be found in Crash Course Psychiatry 4th edition, which is where most of this information has been gained from. These are the particularly relevant civil sections. When and how to use the Mental Health Act. So, let's take this particular scenario. A patient with known schizophrenia is on a medical ward after needing an operation. They are refusing their schizophrenia medication and suffering delusions as a result. They have said they have voices telling them to hurt one of their relatives and intend to do so once released and are threatening to leave. What section can we use to detain this patient? Section 5, Part 2. So, this means they already have a known condition and are an inpatient, and they need reviewing for their own sake and the safety of others. This section can prevent them from leaving immediately and can be upgraded to a section 2 or 3 if required in the long term. Scenario 2. A man is standing in the middle of the road, dishevelled and distressed, talking about messages received from the radios of cars and seems to be having delusions. What is the most appropriate thing we can do in this situation? Section 136. The police can remove this man from the public for 72 hours for assessment according to this section for his own safety. Scenario 3. The gentleman in Scenario 2 was found to have a psychiatric disorder and previous hospital admissions. Subsequently, he was admitted under Section 3 for 6 months. Whilst in hospital, he became more lucid, and the doctors in charge of his care decided to make a change. What is this change? Section 17. A community treatment order, as the patient is stable and seems well enough to look after him. So, let's find out what you've learned. Question 1. What section allows people with a known diagnosis to be detained for treatment? Is it Section 2, Section 3, Section 5, or Section 136? The answer is Section 3. Question 2. Which of the following statements is false regarding the Mental Capacity Act? The legislation came into force in 2005. There are certain decisions that can never be made for someone lacking capacity. People can be determined to lack capacity if their decisions are unwise, or a person should be assumed to have capacity until it is proven that they don't. The correct answer is C. People can be determined to lack capacity if their decisions are unwise. A person can never be detained under the Mental Capacity Act if their decisions are just thought to be unwise. There needs to be a medical reason for detaining them under such act. Question 3. In what areas are people with disability protected in accordance to the Equality Act? Is it education, employment and housing, employment and education, no areas, or education, employment and police? The correct answer is education, employment and police. People that are classified as having a disability are protected under all three of these areas in accordance with the Equality Act. So thank you for watching, and that's the end of this video.